four members of the zoning board. Myself, Mr. Mulligan, Mr. Eckholt, and Mr. Cole. Constituting a quorum. Also present are the secretary, excuse me, the building commissioner of the town, Evers, and you expect Mr. Tom. Ladies and gentlemen, the business for tonight include two cases, both of which have been concluded from an earlier hearing. I'm calling case first 2173, in which we did hear some evidence on May 18th. Representing the applicant is Sarah Serrano Flores. Can you bring us up to date?
Yes, I can. Good evening. At the last hearing, we did present the application, and I believe at the time it was continued due to a lack of a quorum to this date, where there would be enough members to vote on the project, and the missing members were going to read in from the last hearing in order to constitute that quorum. So I guess we should confirm that that has happened.
That we have, just, if I recall correctly, in attendance at the May 18th meeting, were myself, Mr. Cole, Mr. Mulligan, and Mr. Todd. I think that Mr. Cole requested to be excused from consideration. Is that right, Matt?
I think it was Mr. Mulligan.
Mr. Mulligan, leaving.
Yeah, my sister isn't a butter, so I recuse myself.
And we accept your request to refrain from considering. Ms. Eckholt, did you have the occasion to review the hearing?
Michael, you're breaking up and very fuzzy. I didn't catch what you said. I'm sorry.
Then I was asking whether you had the occasion to review the evidence that we took. The idea was that we took all the evidence without having a quorum.
I did not. So I have the packet, but I have not, I'm without the benefit of a review of it.
All right.
Because I wasn't there on the 18th.
You could have been, I mean, you could have, there's a provision where you could, if you stated that you had reviewed the evidence, then you would, at this meeting, you would be entitled to join the quorum and vote.
But Michael, you'd only then have three anyway.
It would only have three, but Mr. Cobb heard, Mr. Cole heard, and I heard, so we would, with the second, would have had four.
Bruce is logging in now.
Okay.
I'm happy to also briefly review the application to refresh everyone's recollection, because I think it's been just about a month. I won't go on to the extent I did before, but happy to hit the highlights if that's helpful.
I
It
did,
would be for me.
is there a, Mr. Cobb is not in, once he's in, then it's up to you, Ms. Serrano Flores, now that the next vote, the vice chair is counted present, not having reviewed the previous hearing. If you are able to state a summary or précis of the evidence, then decision whether she feels she's heard enough. There was quite a bit of evidence in the heard before, and you answered a series of questions, particularly from Mr. Cole about the development. Let the record reflect that Bruce Cobb, who also was present on May 18th, has now joined the meeting. Mr. Cobb, we called case number 2173 for further hearing, and Ms. Flores reminded us that with the Mr. Mulligan having excused himself from consideration, we didn't have a quorum at the last court to decide case number 2173, the application of Pleasant Bay Ranch then, but we could if two things could happen. If we reopen the hearing for the, so that we had a quorum, and we now have a quorum of 4 members, or if any absent members who are present at this hearing had reviewed the either the transcript or the videotape of the hearing. I'm requesting Ms. Serrano Flores to summarize the presentation for the benefit of Ms. Echols, and then we'll determine whether Ms. Echols has any questions or feels comfortable having reviewed the application, but not the benefit of the last hearing so that we can decide this. Is that a fair way of putting it, Ms. Echols?
Yes.
Ms. Serrano Flores, are you willing to proceed under those circumstances?
Yes.
Very well. Then would you please?
Sure. The applicant, the property is at 71 Tohi Lane. It consists of 53,496, so just about 500,000 square feet of total lot area, 44,204 of which are the buildable upland. It's currently improved with a single family dwelling that is pre-existing non-conforming in as much as it sits too close to the coastal bank to meet the coastal bank setback under your zoning bylaw. The proposed project involves raising and replacing that existing single family dwelling with a new single family dwelling. The new single family dwelling is larger, but it is shorter, it's smaller in height, and also pushed back from the coastal bank on this property, which wraps around from the south over to the west side of the property. So this is now set back over 55 feet from the bank on the west and 88 feet from the bank on the south, which is the south facing bank is the water side. The bank on the west is a more technical coastal bank, but it is one, and that's where the existing violation is. So the new project will now correct and eliminate that pre-existing non-conformity. We're in front of you not because of any setback violation or height violation, that the house will be fully conforming to all zoning, but we do need a special permit from you folks because under your bylaw, when you're proposing more than 4,000 square feet of coverage on a lot, you are required to get a special permit under your zoning bylaw. We are proposing a 5,540 square foot house. And there's a 350 foot existing boathouse, which is not going to be touched as part of this project. But in any event, that will be in excess of 4,000 square feet and thus triggers the need for the special permit. We're still well under the 15% lot limitation, though, of the buildable upland. We're only at 13.3% of that buildable upland. So we conform to lot coverage, we conform to all of the setbacks, building height, including the setback from the coastal bank. We're just here for the special permit under your bylaw for 4,000 square feet in excess. As I mentioned earlier, and I went through all of the criteria under your zoning bylaw for a special permit the last time we were here. And it is also included in the written narrative. I just wanted to touch on a few things. By pushing the building, the coverage, roof coverage back and away from both coastal banks, we wind up creating an improved condition on the lot where 1,212 square feet of roof coverage is now eliminated from the 50-foot buffer zone. This is a wetland issue, but it does touch on your zoning criteria of whether or not the proposed project is adequate for the lot size is adequate for the proposed site, and also if the site is suitable for the proposed use. This is a coastal property, and obviously there are environmental sensitivities in these buffer zones, and where the existing house sits and sort of squarely within that 50-foot buffer, we're now restoring it. We're taking over 1,200 square feet of roof structure out of that buffer, and creating now an undisturbed and planted with native vegetation 50-foot buffer, where there was previously now lawn and structure. So that is a very big improvement. We're also, in terms of the method of sewage disposal under your criteria, taking the existing septic system components, which are on the seaward side of the house, and moving them to the landward side of the house. It's now going to be a totally new upgraded Title V system located entirely outside the 100-foot buffer, which again is more protective of groundwater. The other thing to highlight is that to your criteria concerning groundwater quality, as well as the abutting coastal surface water bodies, the creation of that native vegetative buffer includes the planting of 592 native shrubs and 25 new native trees. So this native vegetation creates this buffer zone, combined with the root structure of these new species will not only improve wildlife habitat, but they will stabilize the soils and sediment along this 50-foot buffer, thereby protecting the groundwater quality and the abutting coastal surface water bodies. So those are definitely the highlights of the narrative with regard to why we feel the special permit is justified in these in this instance. We feel we meet that criteria. The last time we were here, there were some questions regarding the size, and that we were at 5,500 square feet for the house, larger than some of the applications before you. I did look on the assessor's website for the houses in the immediate vicinity. And I did discover that this is in keeping with the size of those homes, as well as the aesthetic of those homes. Directly next door at 77 Towey, the combined roof coverage is 6,950 square feet in area. That's got a house, a pool house, and a boathouse. So in excess of what we're proposing at 121 Lake Drive, 5,862 square feet. For Ewing is 5,664 square feet. To the west, they're even larger. 53 Towey has a combined with house and guest house square footage of 6,941 square feet. 43 Toei is 6,019 square feet, and 39 Toei is 7,792 square feet in area. So I think that we're in keeping with the size of the properties in the neighborhood. I will note that 53 Toei was one that I represented the owners with a special permit here for the same reason, the 4,000 square foot special permit. Like that project, I think that this is in keeping with that neighborhood and does not derogate from the purpose and objectives of your zoning bylaw. And for those reasons, we respectfully requested to grant our special permit. David Little is on the phone. If there are additional technical questions, I know Mr. Cole had some the last time we were here, but I can also answer any of the questions for the information that I just reviewed. Thank you very much.
Thank you. Ms. Echo, do you need if you have any questions about the application?
I'd like to hear, Matt, if there were other questions that you had that were significant, hopefully you can remember from a month ago. I'd like to hear what you asked and what your concerns were, and were they satisfied?
So my recollection is that they were satisfied. My questions really had to do with volume and massing, I believe, and making sure that it's interpreting grade and elevation and how that volume of the house presented. Am I remembering that correctly?
That's my memory.
I believe so, Mr. Cole.
I think you also had some questions about the patio, Matt, on the hardscape on the seaward facing side.
That's right, because there were some retaining walls, Lynn, necessary to hold the earth up. So, took a little bit of questioning, but I sort of figured out the drawings after a little back and forth.
Okay. I don't have any other questions, Michael.
Very well. Is there anyone present tonight wishing to speak in opposition to this application for special permit which seeks relief from the cap of 4,000 square feet of building coverage? I hear no response. Then I will declare the hearing closed for taking of evidence and ask for the comments and sense of the board. I move that the special permit application be granted without conditions.
Second,
Second by Ms. Echo. Is there any discussion on the motion?
Could you just clarify, is it 4 votes on this, Michael? Is there 4 of us voting?
Yes, to all. Then we'll vote by a roll. Monarch, yes. Ms. Echo,
yes.
Mr. Cole,
Yes.
and Mr. Tom.
Yes.
Very well. The motion carries unanimously, and I will write the opinion. Mr. Flores, I ask that you favor us with an electronic version of findings, which will assist me in drafting the opinion.
Certainly.
And do that directly, but at earliest convenience, because this is one of the decisions which I need to file no later than June 30th.
I'm sorry, I didn't catch that last part. You were breaking up a bit.
Yes, I need that submission, just to bring.
I think you're asking me to submit the Word format sooner rather than later, if
Yeah.
that's what you're saying.
Yeah, because my incumbency
Okay,
is drawing a screeching halt.
I had to turn off my video the last time I was here. That seemed to help with the audio, so maybe that we're all having wonky internet lately, but I will do that. Thank you very much.
Thank you.
Good night.
Next item, thank you for moving that application forward. I have one more application, and that is case number 2172. Now, this was continued from May 4th. This is the application of David Currier on behalf of A.J. Luke for a special permit in accordance with General Laws, Chapter 48, Section 6, 16444, which is the special permit section of the town code, and the present use of the building is office space and apartments. Now, the applicant proposes to use this as a retail cannabis shop and apartment. The applicant states the planning board and the site plan review of the town of Orleans have heard this and approved it. The reason that we postponed this was and we took no evidence at the time because the question was raised by the town planner then and again as to whether the applicant needed to have the come in with the approval of the state commission. And there was an interchange between from Mr. Meserve had renewed that suggestion within the past week by an email to Mr. McNamara, counsel for the applicant, to which I, at least, and maybe I believe other members of the zoning board were copied, and Mr. Meserve is not present at this meeting. I have spoken with Mr. McNamara to ask his position, yes, and maybe I should allow Mr. McNamara to speak for the applicant on the question of whether this hearing can proceed, given that the State Cannabis Commission hasn't acted on the application. Is that a fair way of putting it?
Yes, thank you, Mr. Chair. So in our conversation, we relayed that, I apologize, there's a burden back on me. The bylaw that Mr. Meserve cites states that that all the applicant shall have all final permits and licensing issued from the state before proceeding with a special permit. And in our conversation, I relayed that the bylaw as it's written is actually impossible to achieve because in order to receive all licenses from the Cannabis Control Commission, we actually have to have zoning in place, which of course requires a special permit. So in our last meeting, the indication from Mr. Meserve was that our presence on the list of entities that had applied for a license would be adequate at that time. And in his most recent response, I think he indicated that there was another level that was required. However, if we take that bylaw literally, unfortunately, not only won't we be able to proceed any further, but other applicants will not be able to proceed any further. I can say that, since over a year ago, beginning in March, this organization has proceeded through several levels of approval at this community level, including there was a community outreach meeting, which was widely attended, a select board presentation, which again was seen by a lot of active folks in the town. I attended a subsequent meeting to obtain the host community agreement from the Board of Selectmen. After some delay, we also, proceeded through informal site plan review, as most applicants do. Board of Health review. Again, there was no changes requested at that period of time. And we went on through DPW, were reviewed by that board. Then proceeded to formal site plan review. And then again, after some more engineering, hired a traffic engineer to conduct a traffic study, went before the traffic study committee. And we've been interacting with the building department as well, in order to, ascertain, what might be necessary for a building permit. In other jurisdictions, the way that this has been resolved is, I anticipate that this board would put this as a condition to the special permit anyway. But a condition normally featured on one of these special permits is that the applicant must have state licensure. That's very reasonable. In addition, without a state license, this business wouldn't be able to operate, anyways, because the state would have taken away all of their software that's necessary for seed to sale tracking, et cetera, et cetera. So it seems that, we're looking for guidance from the board, under the circumstances. I think the bylaw, was crafted at a time when perhaps the town was less familiar. Meanwhile, this organization is really working very hard to try to hold the property and to go through the necessary approvals. There are a lot of people in town who are constantly asking the question, when is this going to happen? And we, the organization really, has the same sort of mentality of, trying to proceed expeditiously. After this, there's, going to be not only a commencement of, applying for a building permit and then trying to commence build out of the operations. And that's going to take, another year. And this has been over a year already. So I think this simple, request to simply make it as a condition, as every other jurisdiction that I've been to on these subjects has done, would be reasonable. However, it's obviously in the board's hands at this point.
Members of the applicant is setting up the problem with a circular problem. That is that this applicant can't obtain final approval from the commission, the state commission, unless it has in hand a special permit. And on the other hand, the 16440.4E2 requires that the special permit application for a marijuana establishment in the town of Orleans would require the application to include copies of all licenses and permits issued to the applicant by the Commonwealth. So, who could, both of these situations could not be accomplished at the same time. I believe we saw a list of the pending applications with the state commission, which was voluminous. Mr. McNamara, do you have any prediction on for the timetable for the commission to act on your application?
No, that's a question that many clients ask in these situations. The commission is unpredictable. It's a new agency, and it's going through the same staffing problems as everyone. In order to do that, there's many levels of approval that are necessary. But again, I guess the problem here is, that the bylaw does require that an applicant have final licensure, but that's literally impossible without zoning in place, without getting the jurisdictions go ahead. And so I cannot give you a timeline, especially because there's all, the other aspects of putting a business together that are necessary in addition to the rigorous security requirements associated with the cannabis business, including access controls and cameras and the amount of storage that's necessary for the camera footage, building delays, supply chain issues, all of these things are necessary before getting a final licensure. The thing about a cannabis business is it literally requires the applicant to be ready to go. So I make it akin to a pizza establishment. If you were going to license a business to sell pizza, you'd have to get not only the pizza ovens, but the staff in place and all of the manuals that are necessary to operate the ovens, and how you're going to make the dough and what you're going to use. I mean, this sounds ridiculous, but that's what's required for final licensure, including local zoning. So we're looking for guidance from the board on this. I mean, what would a reasonable planning agency do under the circumstances?
Just the only element that is up in the air or to be decided. For example, have the police and fire chiefs received the statement or plan of the proposed security measures? Was the planning board advised of the lighting, fencing, gates and alarms and so forth?
Yeah, I mean, all of that's been determined, and one of the first steps that Dave took was to reach out to police and fire about this, and so I think they've been well acquainted at the point for, they know the building and the building's not changing as well, and we're just enhancing security in that respect.
What I'm trying to drive at is whether there's any barrier to proceeding other than the fact that you don't have in hand the permit issued by the state commission.
I am not aware of any other than a building permit, at the local level.
Then what I'm for guidance from my colleagues, members of the zoning board, is whether we should give some consideration towards proceeding, and if the special permit should be granted, that it be on condition that any required licenses and permits to be issued by the state be in hand before the doors open for business here in Orleans. Now, in that regard, we have, in other words, generally, members of the board, we have considered ourselves to be the last stop on the train line, but we can't do that and honor the section 164-44E. In this case, we have once or twice, only once, we allowed a special permit with a review period a year later, and it turned out in retrospect to be probably a less advised or poor method of handling the situation. Here, the question is whether we ought to give some consideration to proceeding with the special permit application, and if it were granted, to add the condition that the special permit was conditioned upon the license required by the state commission. But say members of the board.
Mr. Chairman, I would propose, based on what I've heard, that we accept Mr. McNamara's representation. This is obviously some sort of catch-22. And for us to attach that as a condition almost seems unnecessary, because as Mr. McNamara pointed out, if they don't have a license from the state, they're not going to be able to operate anyhow. And with that in mind, assuming that were the view of the board, we could then proceed to discuss the actual special permit issues, which I would like and hope we get to and not defer. Thank you.
Very well. Any other comments by members of the board? I'm thinking that rather that the condition is still appropriate, because we're still looking at the bold-faced provision in the town code zoning bylaw, which requires, at least we've given some attention to it rather than ignoring it. I agree, Mr. Taub, that the application would be the same, that the doors couldn't open until the state commission says so, but at least we're issuing a special permit with a particular period of time. So the applicant gets to it and moves it forward, and the public will know that we took a look at that and gave validity, at least a consideration to the town code. That's my thinking.
I thought it was appropriate to be raised as an issue, and I'm grateful that it was, but I think unless anybody's in opposition, I think we can move forward with a formal vote on this one particular issue, if you will.
I'm looking at, if you get a sense of the board first.
Michael, I agree with you. I think we should, if we decide to approve it, we should approve it with the contingency that they get all the state approvals. So I agree with you.
Very well. Is that the sense of the board, Mr. Mulligan, Mr. Cole?
I'm indifferent. I happen to think with Mr. Taub that it's redundant, but it's certainly no problem in doing it with a condition. So I'd support either approach.
Very well. And either one is acceptable. What we're really deciding is whether to hear the rest of the evidence on the conditions of special permit. Mr. Cole, you think we can do that?
I agree. We should continue to hear it, and we can decide whether it should be a condition at the end. Personally, I'm favoring it. It should be a condition, but we'll see where we get.
Very well. Okay, Mr. McNamara, then I don't. Is Mr. McNamara still with us? And
Yeah, I'm still here.
I'm sorry, I didn't.
Yeah, I'm here, got a suit on and everything, my Cape Cod tie. I was ready from the get-go here, so.
All right. Then go and tell us how you, the applicant is satisfies the conditions of 164-44 and then the others conditions that are required by section 40.4.
Okay, so if you don't mind, I'd like to proceed with the presentation we prepared.
Would you please?
Yeah, I'll share my screen. Let's see here. So Seaside Joint Ventures, DBA Seaside Cannabis Company. This is, we began as advocates. This is a picture of the Orleans town meeting at Nauset Beach. I'm sure you all remember, where we attended and had basically advocated for the allowance of these licenses to begin with. And thereafter, we had, decided as a group, some of us, to proceed with one of those licenses. And as the group's composition has been presented in the past, we're all 100% Cape Cod natives, owned and operated by Cape Cod natives. We selected what we believe is really the best location in town that was available. And we did that with local support. There was a lot of support at a lot of our events, and we appreciated that. And the plan from the beginning has been to launch the retail store, of course, and then in the future, though not at this stage, to try to come up with some branding where we can perhaps get some locally branded products out there. And we've established supply partners so that that we can expect to hit the ground running on this organization. There's a lot in the host community agreement, which I'm happy to share, that the town can expect in the form of local benefits and positive community impact. So just a little about these members that I'm talking about. I myself am Tim McNamara, hail from Mashpee, although originally from Barnstable. Adam Higgins is in East Sandwich. AJ Luke is out of South Yarmouth. And Dave Currier, who some of you may be familiar with, is from right down the road here in Orleans. So again, I think, among the applicants that were presented at the time, this was the only organization that really had strong Cape ties, if not any Cape ties. It was unclear at the time, but so this is just some more of the background of the group. That was the town meeting pictures where we were handing out flyers with residents. Earlier in time, members of the group hosted the chief McDonald's at a facility off Cape, just to show him some of the aspects of the regulated cannabis industry. And prior to that, you see a picture of Adam and AJ in the Cape Cod Times talking about the differences between the regulated industry and what everyone was familiar with before, which was the black market as it's known, and the dangers of black market versus the benefits of safety and dosing on the regulated side of things. So again, just a little bit more about us. Dave Currier is a business owner here in town. I'm an attorney as well as a business owner in cannabis. AJ Luke is a family business person and has several stores I'm sure you've been acquainted with. Adam Higgins is an advocate, very helpful in the technology side of things and helping us get operations streamlined, which we'll get to in a little bit. Also an entrepreneur. So, I had gone through the list earlier, but we've been through several rounds of approval with the town. And I think that the organization is well vetted at this point. Every aspect of the business has been examined in detail. And of course, at this level as well here tonight. So there's a little picture of the front. You've all seen it. Lots Hollow 14 was an insurance company and later Latham Center's headquarters. The building really sat empty for a while. I know that it's stated as an office space use, but it's being unused. There's just a lot of great aspects to that. I believe with us tonight is Dave Little, who can go into the site plan a little bit. But proposed hours of operation subject to the wishes of the board under the character of Orleans. Our suggestion is it would be a 7-day operation starting at 10 in the morning through 9 p.m. If Dave is available and willing, I'm happy to move these slides along just to describe some of the aspects. I can certainly talk about them, but I'm not as qualified as Mr. Little. Of course, if he's not available, I can begin to. Oh, there he is.
No, I didn't realize you were ready for me right now. But so we've been through most of the local boards and commissions necessary to get this moving forward. The site is excellent. It offers ingress and egress. It's located between the two Agway businesses. It's in an area that has excellent access to and from the various highways. One of the things that we pointed out during site plan review was that, as we're aware, during the summer, sometimes Eldridge Parkway can get backed up, but we have the opportunity to let people know when they're leaving the store to turn right and go down Lots Hollow Road to Finley Road and Route 28 to avoid any traffic congestion. So I think the site is excellent for the proposed use. We've been before site plan review, informal and formal. We've been to the Board of Water and Sewer Commissioners for a sewer connection to the property. And essentially, I think it's a great location. I don't see any issues with respect to traffic flow, safety, or any of the other concerns that you might have with a special permit. So I'm not sure what else that you would like me to say, but that's pretty much all I have for the time being, and I'm happy to answer any questions from the board members.
No, Mr. Lilly, you could say anything you want about, the way I see it is that there's nothing dimensional to the structure that's being modified, but there is an establishment of a number of parking spaces which are not presently in place. Is that a fair way of putting it?
There is a significant amount of parking, Mr. Chairman. We are going to be reducing the parking a little bit at the rear of the site to allow for sufficient access for emergency vehicles and fire vehicles to get around the site. And that's all been reviewed by site plan review. So yes, thank you.
Very well.
Thank you, Mr. Little. Yeah, as Mr. Little indicated, the parking here is not only good, but it is more than double of what other applicants in town had. So we felt good about that you know, there would be limited congestion. This is just an overlay of our initial floor plan design, just to show the board sort of how the layout works. Actually, the entrance and the exit is through the rear. So folks would park in the rear of the building, enter through that rear door, and to the right over here as you enter. After your ID is checked in here, you either have a patient ID or a valid driver's license over the age of 21. And you would not even see anything inside the facility until you would come in those second set of double doors. This is known as a man trap. You know, really the goal is not to trap a man, but to get that person inside, you know, securely, and they would be able to shop here. At the front of the building, you can see these doors and this stairway. The plan is to have a curbside pickup. So again, efficient transactions with the help of some software and Mr. Higgins, we anticipate being able to, you know, have a very efficient operation. Coming in there, some arrows, and you know, there's the curbside pickup. On the bottom, there's a plan to because when a delivery of product comes in, it obviously needs to be very secure. So not interrupting operations going on the sales floor is imperative. Deliveries will be able to come in a similarly secure manner. Only agents registered and background checked to this establishment, or else other agents and third-party transporters that are also licensed and background checked by the state would be able to enter through these doors in order to deliver product. And again, not having to go through the general customer population is an added element of security that isn't required, but is an additional safeguard on this particular business. Here you see a car coming in. This is the order to go process. I think we all know how that works, but somebody did a very good job at designing this particular slide. The order would place, somebody would come out to deliver the product. So the next slide concerns what from the beginning the organization really knew it wanted to do. Take every effort really to try to mitigate any traffic issues. We're familiar with the area. Agway itself is always busy on a Saturday morning, especially in the spring. And so, we're talking about expansive parking here again with the ingress and egress. The organization is coordinated with the owners of Agway. There's going to be some sharing of detail costs to the extent they're needed on busy days. The business itself is intended to really avoid a lot of the morning traffic hours. And normal shopping hours anyways would commence at 10 a.m. So that was why the proposed hours began a little later in the morning. And the technology that cannabis companies in general are required to have by the state really mandates that we have the ability to make sure that people can order ahead, order efficiently, pick up their product, and return home. So upon opening, with the guidance from the chief, we would be willing to add additional security and concierge staff. This is typical in any cannabis business opening, just because there's usually an initial interest in a new business like this. It's probably less necessary in the future, but of course, the organization would always abide by the chief's recommendations or requests, just to make sure that being a good citizen. I guess that's really all we had to share in terms of visual aids, but I did want to, the cannabis business is new for everybody. And there's usually a lot of questions, and I think that the board, I just want to encourage the board to ask me. I've been doing this for over 6 years now, so I've seen pretty much everything, and I tend to have a lot of the answers, but if I don't, I'm happy to get back to you on any of those subjects.
Mr. McNamara, retaining the second floor for apartment?
Yeah, the second floor is actually really just going to remain the same in terms of a floor plan. Here's a picture of the elevations. I think some of you should have the drawings as part of your package. This is the more detailed floor plan. Let's see here. Yeah, this is the second floor. Really, all that's going to happen on the second floor is that the stairway that is presently an indoor stairway going down to the main level, which is you see the new order ahead waiting area. That stairway will be removed, and another form of egress will be put in. And so there's really no change to the floor plan on the second floor. So there's 2 apartments here today, and that's what's going to remain in place. This other area is just going to be office space to the extent it's needed for the operation. I don't know what else I can show you.
I'm,
Yeah, downstairs. I will mention sorry, Mr. Chair.
it's a diverted question. What is the zoning district?
The zoning district, geez, it's been a while since I looked at that.
I believe it's
General.
industrial, Mr. Chairman,
It's general.
or general.
You see,
general.
I'm just looking at the 16444 allows a special permit from the zoning board of appeals under 16444, which, of course, the zoning board is quite familiar with. But in the case of certain districts, there's an additional requirement that it satisfies 16438. That's commercial. And I conclude that the special drafting and insertion of 16440.4 marijuana establishments then determines that the will of the town is that only those 8 considerations under 16444 apply, and we needn't look at 16438, subject to any comment by the board. That's my determination. Mr. McNamara, do you have any thought on that?
If I could look at the bylaw, I would. I'm just sharing my screen. I've looked at it many times in the past. I just don't have a comment on that at this time. I'm happy to answer that question in a follow-up email. I guess when I said I could answer most questions, it was relating to the Cannabis Control Commission regulations.
We would consider this to be a commercial use, then, and there was a special permit required under 16413. Then there was a batch of additional considerations. The board would need to take evidence of those and conclude that doesn't apply. 16440-4 did not carry forward those considerations contained in
Mr. Chairman, we're having a very difficult time hearing you.
Excuse me, I will try to speak slower and more deliberately.
Mr. Chairman, could I ask for a point of clarification?
Mr. Todd, yes.
I am confused as to the basic question in front of us, which is why does this need a special permit?
Because 164, there's a special provision in the zoning bylaw, which relates to marijuana establishments. And that's 16440.4.
And what specifically about that causes it to come before us?
Let me just go back. I just had it on my screen. I've got to go back.
We could ask the building commissioner why he sent it over. No, did this go before the building commissioner yet?
It's
No, no, Mr. Taub.
it's in the general business district. And when they allowed marijuana retailers, it says under the use tables that it is allowed in general business, but requires a special permit.
And Mr. Taub, it's 164, 40.4, E, which says, in section 1, and a marijuana establishment shall only be allowed by special permit from the zoning board of appeals in accordance with the state statute, chapter 48, and 164-44 of this bylaw, subject to the following statements, regulations, conditions. That includes that the application had to have the names of the players of medical establishment, people involved, the ability of the applicant to use the site, like whether it had a deed or a lease, and proposed, among other things, proposed security measures, which included lighting, fencing, and other considerations, which should have been sent by the applicant to the police and fire chief for review and comment. And then the zoning board needs to find those provisions of section 164-44, Mr. Todd, including findings that the facility is designed to address any environmental, visual, noise, odor, traffic, or economic impacts on abutters, and the facility demonstrates that it's met all the permitting requirements. We have some evidence that all the town boards and agencies that have jurisdiction over this development proposal have already passed on it. And finally, that the applicant has satisfied all of the general and special permit requirements of 164-44. And that's why, that's the mechanism and procedure why this applicant is proceeding under 164-40.4 and looking for a special permit.
Right.
Thank you,
So
Mr. Chairman.
could I just continue? So I appreciate that. And I think it's important to understand that we're just reviewing it now under the existing criteria that we routinely view special permits, impact on the neighborhood, noise, traffic, etc. That's what our inquiry, if you will, is limited to.
I hesitate to say it's limited by that, but it certainly is.
Well, okay, I'll rephrase that it's the focus of our efforts here tonight.
Yep.
Mr. Chair, are there some considerations that you're referring to that need to be addressed, or are you saying they don't need to be addressed?
Yes, but the provisions of the commercial findings aren't necessary under 164-38. Just wanted to put that out with the board, so to and my thinking as to why they don't apply in this case. Since the marijuana establishment bylaw only plugs in 164-40, which, as I mentioned before, the board is quite familiar. It's familiar with section 38 too, but we don't need an extra level of findings, is what I'm saying. Matt.
I see.
That is my determination and ruling, subject to any commentary by the board. Is there anyone present wishing to speak in opposition to this application? I see no one present at this meeting to having raised a hand to speak in opposition. Is there anyone wishing to speak in favor of the application? And I see no positive response. Let the record reflect that the zoning board is not in receipt of any correspondence from abutters or any other persons of interest, either favoring, oh, excuse me, let me take that back. I think I have received, I think the board does have, is in receipt of some dated, that is pre email or some similar correspondence favoring the application. I don't have it in front of me. I'm not aware of any correspondence in opposition to the application. Now, having, is any other member of the board wish to inquire of the, Mr. Francolini, you're recognized.
Yeah, can you hear me okay?
Yes,
Yeah, I'd like to remind the board that as part of the Cannabis Control Commission process, there was already an extensive community outreach public review. And that's when the community, either expressed their support for or their lack of support for this application. And as I remember it, the support was overwhelming. And, although it would typically be the zoning board that gets that input from the community, it really wasn't the case this time because the Cannabis Control Commission has that procedure in place where it's done earlier on. So I just don't want the board to think that there's a lack of support because of the fact that you don't have supporters here tonight.
point taken, Mr. Franklin. We're principally concerned, as we usually are, with applying the criteria from the zoning ordinance or zoning bylaw, the application. We were, what your point that the public comment periods have had their time, and the fact that there isn't been a hue and outcry either way before this zoning board, that does concern us. And thank you for that comment.
Unfortunately, I couldn't understand almost anything you just said, Mr. Chair, but my apologies.
Very well. Any further questions by any members of the board?
Yeah, Michael, I have one. Does it make sense to have 2 residential apartments above this business? That's question 1. Given sort of there'll be some traffic there. It's going to be pretty busy, not because of the nature of it, but because of the fact that it creates a lot of traffic and might even require some police traffic control on certain days, or at least initially. And the second question is, well, if it's presumably it's allowed in this general district to have a residential apartment, and so is it simply somebody's risk who chooses to live there? They know they're living in a place that is extremely busy.
I can't answer that question, Lynn, but maybe Mr. Little can put a gloss on it.
Thank you, Mr. Chairman. As a matter of fact, Ms. Eichholt, one of the current renters in the building has expressed an interest in working for the people that are going to be
Okay.
running the operation. And yes, it is an allowed use.
Yeah, I figured it was. Just wondered if it's appropriate. But yeah, okay, that makes sense.
Mr. Chair, if I may add, I think that, the reason that the apartments were preserved, part of this is in the interest of providing, housing period in the town, that's affordable. And if one of those individuals gets to commute to work via going outside and coming in through the storefront, then that's a benefit to both the business and the community. So that's why really that it's been preserved in that manner.
Very well.
I
Mr.
saw
Chairman.
Mr. Courier's hand up, Mr. Chairman.
Mr. Tom?
I said I saw Mr. Courier's hand up, Mr. Chairman.
I didn't. Oh, yes, Mr. Curry, yes, you're recognized.
Yeah, I just wanted to, on that subject, wanted to say, as a current business owner in Orleans, workforce housing is the talk of all of us. We are dying for housing, and to the point where those of us are purchasing housing just specifically for housing. And so it's really important, and I would love to keep those 2 apartments, because that's all we talk about. It seems like in all these Orleans meetings or workforce housing.
Could I make one observation, Mr. Chairman?
Would you please?
The pre-existing nature of the apartments leaves me satisfied that they're okay. But from a hypothetical perspective, if this establishment were operational and then asked for a permit to put 2 apartments in over it, I bet you we wouldn't let it. So just a comment. I don't think that that's a bar in any way, but I just wanted to share it.
Thank you, Mr. Tom. Mr. Cole?
So I appreciate the presentation, and I think I understand the proposal. What I don't think that's been sufficiently addressed is the criteria in 164-40.4, and specifically letter E, the special permit requirements. So I think we benefit from the applicant explaining how the proposal as it's filed now addresses that special permit requirements and the bylaw more specifically. There were a lot of generalities shared, but 160-40.4 E2 has some pretty specific requirements in it, and I think it'd be important to have that captured on record.
Very well. Mr. McNamara, can you queue up or have you, can you state the name and address of each owner of the the marijuana establishment? That those were the yourself, Mr. Currier, Mr. Luke, and Mr.
Higgins.
Mr. Higgins. Is that correct?
Yes, those are the owners of the company. So
And your addresses have been disclosed in the application.
yes,
Very well. The second we've talked about already, that is the licenses and permits. Those are available. Those town considerations, site plan review, for example, or planning board, those have all been accomplished and are part of your application.
correct.
I confess that I don't have the electronic version of the application in front of me, so I can't comment on it, but I'm asking you whether that's been done.
Okay,
The third was have you provided evidence of the deed or a lease, or I suppose an option to purchase?
yes, and Mr. Luke is on this meeting. He's the owner of the building.
All right, okay, well, that's fine. If the applicant is a business organization, a statement disclosing all of the owners, shareholders, partners, members, managers, directors, or other similarly situated individuals and entities and their addresses. If any of the entities are rather than persons, if any of the above are entities rather than persons, the applicant must disclose the identity of the owners of each entity until the disclosure contains the name, until the disclosure contains the names and addresses of individuals. I take it that the business organization that is Seaside, the only individuals who are involved or in management or in ownership of Seaside are the 4 individuals that you've disclosed in section A that we've discussed already.
Yes, that's correct.
Very well.
And then on the last item, E, as we described before, we've been, reviewing these plans with the police and fire chiefs for reviewing the comment. We do have, at this stage, a security plan in terms of, camera location, et cetera. Some of this stuff you don't want to just send around to anybody in particular, but we can certainly provide that documentation as part of the special permit. And I can forward that to wherever you'd like.
So two follow-on questions there. Could you put the site plan back up and just talk about lighting, fencing, gates, alarms, just sort of physical security measures, and then back to letter C. I think I heard you say that one shareholder or one business owner owns the building, so the operator does not own the building. So I guess for a point of clarity, will this special permit run with the land? I presume not, right? So what's the term of the lease that the operator has on the building, and how does that relate to the term of the special permit?
So the owner is indeed on the call today. There is a lease in place between the entity and the building owner. Are you guys looking at my screen now? Is everyone able to see my screen?
I'm actually
Yes.
looking at the 164.40.4, but you may proceed. I can.
Oh, right, of course.
Okay.
So, to try to address this in a little detail, I'd like to have a picture of the floor plan up just so that the board can sort of understand. So there's already spotlighting, that surrounds the premises and lights all areas. This is part of the requirements by the Cannabis Control Commission. Inside of the building itself, and in order to get into the building, there are access controls that will be installed. So those access controls need to verify, they'll be controlled by, a central processing unit. But it basically, you have to have registered agents that are put into your system that can either get in by BioTrack controls or by RF transmitter, a keypad. Sometimes you use all the above in case somebody forgets their tag. So nobody gets into or out of the facility without their credentials, essentially. Those can be removed and added as someone is onboarded or fired, or as they quit. They can be immediately cut off from access, not only into the building, but in certain rooms. So if you look at, for example, the retail vault, which is scheduled to be located in the center of the building, only managers and perhaps an assistant manager, when they need assistance to open, will be able to access that retail vault. So entry-level employees will not really have access to that area. During the sales day, you're able to take material out of that retail vault, and if you want to put it on display in, behind the counter, or if you want to, some operations have, in-store displays. Nothing is planned for that with this operation. But in any case, at the end of the day, that inventory needs to be taken off of the sales floor and locked up in the retail vault for safekeeping until the following opening. All of the material that is in the building at any given time needs to be logged into the state's seed to sale tracking software, which is called Metric. That's METRC. It's pretty much in every state. That software interacts with your chosen point of sale software so that when an item is sold, that is basically when it leaves your seed to sale tracking. Again, the seed to sale tracking software pinpoints exactly where that material is. So when it's in the retail vault, the software knows it's in there. When it's on the sales floor, the software knows it's in there, as well as any other storage areas that the facility may have. Another unique feature about cannabis businesses, which is burdensome, to be honest, is that every square inch of this facility needs to be covered by some form of camera footage. At the entrances and exits of the building, not only does it have to be camera footage, but you have to be able to identify the person coming in or out. That camera footage also needs to be stored for 90 days, which I don't know how many people in technology are in the room, but I've learned that 90-day storage is so astronomical that these businesses inevitably will need a whole rack of servers in order to store that material for that long. So, you know, the building is going to have so much technology in it that it would, you know, eclipse pretty much any tech building in town, in addition to the security measures that I was speaking about. What else can we talk about? You know, anybody entering and exiting, again, I think through the man trap is, you know, identified before they're able to even see inside the building. You know, we compare this to liquor stores where you can sort of walk by and look inside. That is not the case here. And so, you know, the police department, as well as the Cannabis Control Commission, are going to ask for an IP address so that if any incidents occur on the premises, they'll be able to log in and immediately determine who, what, where is something occurring. That enhances their ability to be safe in those instances, but also, again, there's no other such requirement in any building in town, whether it be a CVS store or a bank for that matter. So I always believe that, you know, these are going to be the most secure buildings in any given town. And I think, you know, at times I think it goes a little overboard, but it, you know, sometimes makes people feel safer. So we have that. I may be forgetting some details, but is there any specific concerns that I'm not addressing here? Security, visibility.
So I guess just confirming that the building and the property will be well lit at all hours, and you've got security cameras canvassing inside and out. So if there's an incident, getting footage in the hands of Chief McDonald or whomever would be a fairly routine measure.
Yeah, and you know what we usually offer, and we have to the chief is, you know, if there is an incident, we'll make sure that there is, you know, a copy of the relevant footage, you know, available to him as soon as, you know, somebody can be on the premises to provide it from and download it from the memory. Typically, they'd want to take that memory stick and put it as part of their police report. So.
I guess last two questions, and hopefully they're brief. The traffic study that you guys did, do you know how many trips per day in and out of the facility you're expecting? And then second question, somewhat related, is the hours 10 to 9. Is that sort of the initial experimental hours, or is it part of your license with the state to establish that and not change it? How should we think about what, how those hours might change once you're operating?
I can't speak to the trips. I don't recall those details. Perhaps Mr. Little or Courier can fill us in on that. As to the hours, they're very much, you know, proposed hours. I think that the organization envisioned, you know, that people need to, you know, have time after work to be able to visit the place. There's, you know, we have to consider the Cape traffic in the summertime, people arriving on Cape late, but not too late. You know, I always tell groups, you know, like we kind of have to take the planning board's guidance and really see, you know, where we end up in terms of, I mean, we've had discussions internally about it, you know, summertime versus wintertime hours. You know, I think it really needs to be tested to figure out what works best. But of course, this board is the one that, would really say what would be appropriate on the other hand. I think that the Cannabis Control Commission doesn't allow you to operate all night long. So there, you're within the limits of daytime hours up to a point. But on the trips, all I know is that the result was good. I don't remember the statistics on the trips. But I think that the committee may have sent that information to the ZBA. But we can email that to you for sure. We do have that information.
Mr. Chairman, I have another issue, if I may.
Yes,
I'd like to circle back to the issue that Mr. Cole raised earlier about the ownership of the property. The section 16440 says the special permit shall remain exclusively with the applicant, who shall be. I guess the question is, we know Mr. Luke owns the building. Does the applicant, who are the four individuals, do they have a lease with Mr. Luke?
That's correct.
Okay. You answered the question that Mr. Luke owned the building, but you didn't imply, I don't think you stated that the applicants have a lease with Mr. Luke.
I'm sorry, the organization has a lease with the owner of the building, and the owner of the building is Mr. Luke, who's on the call and may verify that.
No, that's fine. Thank you.
well, I am concerned that if you're Mr. Cole's questioning and the principal feature of the zoning board's consideration, I think, is the traffic. And therefore, is it, I'm inquiring philosophically, is it subject, should this board attach a condition if the special permit be granted to regulate or set down the powers of operation by the application? In other words, to fix the time of 10 to 9. Polo Road is a narrow road. We're all familiar in having, taken a view of the property of the traffic in and out of Agway, the traffic to the automobile dealership, the hockey rink, and the transfer station. To add a layer of, which is somewhat of additional traffic, which is somewhat speculative, but considering that the application builds in 40 parking spaces, is a major modification to the traffic pattern on Polo. And bearing in mind that the fire chief and the police chief have passed on the application, is it maybe none of our business at this point, or should we be inserting our own best judgment on a condition of hours of operation, which ought to, say, put limits on the traffic which would be created to service this particular location? Just it's not a real random thought. I think Mr. Cole put it right on the table. Any commentary?
Yeah, Mr. Chairman, David Little.
Yes.
So the site is unique. It's surrounded by Agway on two sides. And as you're aware, that the intersection as you come out on Finley Road, the Eldridge Parkway can get congested in the summertime, but the site also offers a unique situation, and they can explain to clientele when they leave the site, depending on where they're going, they can turn right and go down Finley Road or Lots Hollow Road to Finley Road and then enter onto Route 28. So there is, this site offers a significant opportunity for this purpose. I can't express enough between the parking spaces and the two means of egress in and out, and then the two means of egress in and out on the highways, how this lot and site lends itself to this proposed use. Thank you.
Thank you, Mr. Little. Well, it's more to it than that. If I remember correctly, we permitted Agway to actually, in substance, would surround this property on three sides. Agway was in looking for to be able to run a traffic pattern from the facility where they were sold pet supplies and some building materials to go around to the right and come out over by on the other side where the garden center was. So there's nothing to prevent this applicant from alleviating the traffic by joining with Agway in some kind of an easement. But on the other hand, to trust the patrons of Seaside to take a right on Lost Hollow Road and then go down Finley is asking too much. Although anyone who's experienced taking a left onto Eldridge Parkway to the lights from Lost Hollow Road knows that can be impossible, especially we'll say right now in June of 2022. It may be okay in January of 2023, but that is not a we'll say a user-friendly pattern, and trusting the patrons of Seaside to alleviate it, I might be asking too much.
No, you bring up an excellent point, Mr. Marnick, and I'm not saying that the patrons should choose to do that. I'm suggesting that the owners will give the opportunity and let the patrons know that depending on where they're going, they may run into traffic and they may be alleviating certain issues. With respect to traffic flow and safety, I think that both traffic flow and safety have been addressed by this this application. It's a very appropriate site for something like this. And if this business has even 1/10 of the clients that come in and out of the two agways on either side over the course of a day, they'll be making millions.
That may be so, and I think that everyone present at the hearing will realize that the zoning board shouldn't be in a position of micromanaging all the details of an applicant's operation. That I'm only restricting my comments now on traffic patterns and traffic flow. I think it's up to the police chief to determine whether exit traffic from this locus ought to be right turn only to go down Lost Hollow Road. That may have been something that was investigated and decided before, and I don't know specifically whether that ought to be the business of the zoning board, and I'm just proposing it. It's within our jurisdiction, but generally those kind of details, we've trusted applicants to use their common sense and being good neighbors to not only to Agway, but the other residents of the town.
Well, all I can say, Mr. Chairman, is that we attended a preliminary site plan review hearing, and we attended a final site plan review hearing, and we obtained approval for the project. And those considerations are foremost with what they review on a project.
And generally speaking, it's good enough for the other town agencies and boards, they're good enough for us. Especially if there's expertise involved with their consideration.
Mr. Chair, I would just add that, you know, this town has the benefit of having a traffic committee. I don't see those everywhere, and the police chief is at the head of that committee, and so he's had opportunity to speak to that, but there were, you know, no suggestions. But I think we, again, to Mr. Little's point, you know, the organization does want to inform its customers that, please take a right, be polite here, and it'll benefit you, because of the issues you're speaking of. Everybody's going to be happier in the end. We can provide the memo that was provided by the traffic committee, and that may help, fill in some of those details.
Mr. Courier wanted to be recognized, and you are.
Hi, 2 points. There was a memo sent into the ZBA at May 3rd from the Traffic Study Committee. We went through that and there was no problems there. And then speaking about the hours with the traffic, in the very beginning, I live in Bakers Pond Road. For those, I've been in front of you guys and I've seen a bunch of you guys, but maybe if you don't remember, I do live here in town, so I know that intersection well. I remember it back before they moved it. And when I was telling these guys, I told them about that intersection when we first got underway, and I called Josh, the owner of Agway, in the very beginning, and he told me about the top 3 times that are the toughest times to go to exit onto, take a left onto Eldridge out of Lots Hollow. And he said the first one, the worst, is the morning commute. Just all the landscapers coming out of the industrial park, and he says it really cleans out after about 9:30. That's why we chose 10. So we avoided the number, and that's what this is. I didn't do the study, and I'm not, but Josh is pretty good boots on the ground. So we decided to do 10 a.m. just to not even get involved with that early morning rush. And then the second one, actually the other 2 that he mentioned are really something that it's just hard to control, and that was when the buses leave the elementary school, the 180 days a year. He said sometimes it gets backed up that time. And then the other one was, July, August at the end of a good beach day, everyone coming off of Nauset Beach. So those are the times he said that we got to, if we can somehow help that. And that's why Mr. Little said, maybe we direct people at that 180 days a year for that half hour those buses are leaving. We'll try to tell them to go down Lots Hollow and then down Finley, and then also during the afternoon in July and August when they're coming off of Nauset.
Very well. Is there any other questions from members of the board? Is there any reason why we shouldn't close the hearing for the taking of evidence? And I'm declaring that the evidence is complete. I'll ask the sense of the board. I move that the application for special permit under section 16440.4 be allowed without condition.
Second.
Second by Mr. Mulligan. Is there any discussion on the motion?
No questions on the motion. Question on conditions. Anything
No.
suggested?
Very well, so, amend the motion.
Questions for fellow board members, if anyone feels conditions should be added?
Mr. Cole asks whether the appropriateness of allowing the special permit without.
Well, there've been, Mr. Chairman, there've been suggestions. One is a condition that we make it conditional upon them getting all the requirements from the state, which seems a bit redundant, as Mr. Todd started off the meeting, that if they don't get the permits from the state, they can't open anyway. And then the other suggested condition was regulating the hours, and I'm not sure we want to get into that. If we did regulate the hours, I suggest we would regulate the maximum. There may come a time when they want to close before 9 or open later than 10, and I don't think we want them coming back. That sort of,
Mr. Cole, I've come to agree with Mr. Todd that condition, conditioning the special permit on approval by the Cannabis Control Commission of the state is redundant and it's not necessary. My own feeling on the condition concerning hours of operation is there's probably other ways that I see. I happen to be satisfied with the integrity and thoroughness of the applicant and the applicant's agents, that there's if there's an abuse of hours of operation, there's other ways to deal with it, rather than by containing a condition to the granting of a special permit. That's my thinking.
Great. I would go along with that.
Very well, then we'll call for a vote. A yes vote is in favor of the special permit without conditions under 6440.4. Mr. Marek, yes. Mr. Mulligan,
yes.
Ms. Eckholt,
Yes,
Mr. Todd,
Yes,
and Mr. Cole.
Yes.
The motion carries unanimously. I will write the opinion. Mr. McNamara, are you in a position of providing me as the author of the opinion with proposed findings, so in immediate time, so that the opinion can be filed certainly by June 30th?
Yeah, if you don't mind, I'd like to work with you on that. Yep.
Very well. And that would include, I'll review, in the meanwhile, I will review the application. There may be a few, for example, site plan review. If there were 2 hearings there, we need to see the final result and any correspondence that you may have had with the fire and police, that kind of thing, which sort of button up so that the public will deal specifically with those required to be dealt with under the bylaw. And if you could help with that, fine, no matter what, withdraw the opinion and file it by June 30th.
Okay. I appreciate that, and I appreciate, I think the organization appreciates the board this evening. It's very informative for everyone, so
Thank you.
thank
Thank
you
you.
all.
Members of the board,
Thanks, everyone.
we need to deal with the approval of the meeting minutes. Ms. Faber has also provided us with April 20th, May 4th, and the minutes also of May 18th. And we can add that in, even though it wasn't in the agenda. So that's circulated with, at least it has been the past couple of days. Is there any commentary regarding those minutes?
Move the approval of all three.
Very well. Is there a second? I second the motion. Is there any discussion on the motion? All those in favor, this can be by acclamation, aye,
Aye.
and opposed. There's no opposition. That motion carries unanimously. This is there's no other further business to come before the meeting as far as hearings or housekeeping business, except for the election of a chair and secretary, vice chair.
Good night, everybody.
Good night, Tom.
Good night. I did receive an email from Mr. Taub. I don't think that there's any good reason for us to proceed to executive session. I did put a call in to town council, but I haven't spoken with him, nor did he return my calls as far as I know. The determination of officers of the board doesn't necessarily have to be determined tonight, but my term expires on June 30th, and I tend to file all opinions that I need to file before then, and until June 30th, I'll take any other action that's necessary as chair. I've enjoyed my stay, but I think the time is this is the time to pass the baton. I leave it with you, my colleagues, as to how to proceed with the rest of this meeting.
Will you remain as a member of the board and you're just resigning your chairmanship, or you're resigning from the board?
My term expires, Bruce, and I've declared that to refresh your memory, my term was extended. There are term limits in the town charter, and I obtained relief from that 3 years ago. My term was extended, and I don't think it's appropriate either. But nor is it healthy for the board for me to ask for another extension. So to make a long story short, June 30th, I don't
And I
have.
think, Mr. Chairman, if I may, I think maybe inappropriate, maybe premature for us to select officers going forward, since some of us haven't been reappointed.
That's it. That's it. I'll bring that to the attention of the select board. I think that's true. I think that's correct. I have no idea of knowing who is, I do know whose terms are expiring, but I don't know whose terms have been renewed, if at all. Nor do I know who has applied for admission to this very exclusive club, but has not yet been approved or by the select board.
At least I can say two things. One is I haven't let them know yet whether I will want to be reappointed. That's one. Two is it would be typical for a vice chair to assume the chairmanship, but I told Michael a while ago, I can't do it because I have to participate. When we go back to being live, I will have to participate by phone for a few months because I actually go in the winter time to another location. And, I think it will be, it will probably be something like 6 meetings. And I can't be counted as a member of the quorum. I can vote, but I can't be counted as a member of the quorum, and I can't chair a meeting by phone. I don't think that works. So I can continue as a member, and vote, and can do all the work, et cetera, but I don't think I can chair it. So
And
we'll say that.
and in fairness, Lynn, when you agreed to become vice chair, it was never on the condition that that was a lockstep.
No, I know, but I just wanted to,
Yeah.
we had this discussion and nobody else was sort of willing to be a vice chair or chair. And so, part of the issue is doing opinions decisions. And I did say that I would help to do decisions, which I have done some. If I continue for another term, then I can still help, although I have a feeling it should be spread amongst the group, but I can't chair, so. I can continue as the vice chair, but I can't chair.
Very well. Then I think that we could then adjourn and see what happens the first meeting in July. And failing, I think at that time it was held an idea of whose terms have been renewed. And I think, Lynn, your term is expiring too.
It is, yes, I'd have to be reappointed.
Yeah.
I've never been clear on what the terms are. I've been on 2 years. Is that the term, 2 years?
The term is 3 years. Now, whether you came in to fulfill an unexpired term, I don't really know. All I know,
I don't either.
the list has your term expiring on June 30th.
That's right, it does.
Yeah.
And
And that's it.
that's it. So I've been on it 2 years. So I was puzzled as to what the term is. So if it's supposed to be 3,
It's supposed to be 3.
okay. And yeah, I've only somehow 1 year disappeared because I've only been on it for 2.
Well, the fact of the matter is that I don't think that you and I have we ever seen each other face to face, Lynn?
One time.
Very well. Is there any other commentary?
I mean, we do have to plan for the July meeting. Somebody has to chair it, right? Which I can do. But we have to have someone.
Yes, ordinarily you would, as vice chair, you would be managing that meeting. I don't know that we have ever faced the nicety of expiring or expired terms. I don't know if the town was ever vigilant about renewing terms so that there wasn't any break. So I really can't even speak to that. I'm assuming that those of you whose terms expire on June 30th would have and desire to be reappointed will be reappointed. I'll bring that to the attention of the chair, Andrea Reed. I'll bring that to her attention. She's always been the liaison to the zoning board, so we don't see her too much.
Hey, Michael, I made a suggestion about what I called an executive meeting, because sometimes when we're having discussions, I feel like I restrain myself from what would be a more candid comment if we were meeting alone rather than with the public. And I think that most deliberative boards get an opportunity to do some processing some of the time. And in light of these 2 negative votes I had, which I felt that I certainly, it was not without significant confusion, but it felt to me had to do with values and responsibilities and a certain amount of what's ours and what do we pass the buck on that Barley Neck thing. It was easy to say we'd already approved it and any conditions or concerns would be taken on by the board of select persons, the select board. We didn't want to be in the how many decibels or should it be acoustic or shouldn't it be acoustic. But we get in that case where we're going to end up in a court, and in the Fiend case, the Atlantic Workshop case, I'm not sure that we're serving the interests of the town best in the kinds of discernments we're making. And I think it would be useful to have some clarity on that. I think that there's a certain, for lack of a better word, vision thing and how people see the town and what they're willing to permit or not permit. And that's reflected in this board. And if that's not appropriate to discuss at any time, that's also fine, but I wanted to at least raise it.
No,
So
that's,
thank you for that much time.
no, point taken, but that's on me. I've been the chair now for quite a few years, and if there is any kind of culture established in the zoning board, it's pretty much my doing. I have mainly been concerned with transparency in deliberations and the fairness and the introduction of evidence to support or oppose the application. And to that extent, then the decisions of the board have been by consensus, some of which I may have contributed to, or generally have contributed to, but there is the quorums have been appropriate, Bruce, and the decisions have been by the appropriate appropriate number of the members of the board. The fact that one member or another member has objected, or the fact that some members have agreed, but for different reasons, really doesn't, I've never considered that to be of any great consequence. And because the town's business was being done based on what we were faced with. And so in that respect, it's really on me. And I have been less than efficient in establishing uniform policies, although various members of the board have from time to time suggested that I do a better job of that, because I was mainly concerned with doing the business of that we were faced with every second Wednesday. And the fact that there have been maybe some inconsistent results has begun to, or at least in the latter period of my term, have aggrieved me to some extent. But on the other hand, I never felt that in any particular instance, that the will or good sense of the people living in the town of Orleans was ever neglected by anything I've done or anything this board has done by consensus. So maybe there's a better way of doing it. One reason why I haven't felt that it would be a good idea for me to look for a further extension in any event to continue to operate as the facilitator and manager of this zoning board. But maybe someone will have a bigger picture, as you may be suggesting, and I think that's a healthy thing. I just don't think that I was able to do that because that's not the way that I envisioned, that's not the way I took up the board and continued as the chair, and with the way I envisioned the board based on my own experience and knowledge and personal habits. So that is kind of.
I don't need anything more than that, Michael, honestly.
That's an apology or.
No, it's not necessary. I regret that it evokes anything that suggests the need for an apology. I think we're all terrified that you're not going to be around, and your leadership has indeed been very consistent, and stuff, and you're an important voice as well as our leader. So maybe I'm just reflecting a certain anxiety.
I understand that, and I appreciate it. And I appreciate all of you. And now we can adjourn.
Well, we do. I just want to say, I feel the need to have we're going to have to figure out who is a chair, because I haven't even decided yet whether I want to be reappointed. I will chair the July meeting, no matter what, just because we need somebody to do it. But we do. I would assume that someone who is an experienced member would be the chair, not a brand new person. So we really are going to have to deal with that, one. And two, Michael knows, I have, as the newest member, even though they say I've been on it 3 years, it's been 2, I have never felt that we've had a good discussion about issues like precedent and the way we do our process. So I actually feel the need for some of the things that Bruce is talking about, but that's something that can be done when we have a full contingent of members, old and reappointed ones. But we definitely need to figure out the issue of the chair, I think. We can wait till they appoint new members, but I think it is going to end up, it should be an experienced member. Right?
I just want to speak up, Lynn, and I appreciate you raising this, and certainly we need to get this figured out either tonight or at the next meeting. I'm grateful that you're stepping up to chair the next meeting. I just want to make my point clear. I had said a while ago that I was going to be stepping down from the board. I believe I'm the longest standing member. My intention at this point is to stay on the board, but I do not have capacity to be chairman or vice chairman. So I just want to make sure that's clear. And then the second point is really a question of, I'm certainly willing to do whatever I can to help support fellow members, the chair, the vice chair, whatever I can do to help with this transition. I too have been spoiled by Michael's leadership for the last several years. And I guess the proposal that I would make is to see if you're comfortable, if you're the named chair and the vice chair understands that those 6 meetings they will need to preside over, and they accept the vice chair position, knowing that, would you be comfortable as the named chair?
Yeah, I'm not sure, Matt, because, you know, I said 6 meetings, but it could end up being more than that. And I'm really nervous about taking that on, knowing that I go away for several months, and I'm recently retired, and like everybody, has postponed lots of travel, and I probably will be gone in addition to that. So on some
Sure.
travel. So I'm nervous about doing it. I don't think it's the best thing. I think I'm in a better position being the vice chair and helping with writing some decisions, but being the chair, I feel like it'd be tough.
So if you're willing to at least step into the vice chair position, and again, in the interest of time tonight, in light of you saying you're willing to chair the next meeting, perhaps we make a motion and a vote on the other positions, have some discussions offline, and come to the next meeting with the understanding that we've got to get the chair position sorted out, but perhaps vice chair and the other positions could be sorted out tonight.
I think it's very clear, Michael can't leave.
Well, I'm going to do that, colleagues. I am, but I'm finished on June 30th, and then I'll file the decision that they're required to do between now and then. But I can say this, that I can, and then I'll no longer be a member, but I can do this. I can do a training or 2 on the preparation of the decision. And I could do that in a very informal way, so that people who might have to prepare a decision will feel comfortable doing it. And so that's my offer, and that's outstanding. I did approach, I know the town meeting approved the position of an assistant planner, and I thought in my heart of hearts that maybe the assistant planner would be able to write the decisions or do some of them. And I'm told that that's not what was in the, that's not the reason for creating a position of an assistant planner whose job description doesn't include that. Oh,
You know that the town planning department and the zoning board were one and the same for a period of time in Orleans history, and there was a specific vote to separate them. And I think in some ways, as we experience these questions of what's in our purview to decide and what's not in our purview, that overlap is manifest. I wonder, Mr. Mulligan, since you're undeclared at the moment, whether there's any possibility that you could be induced. I know this is outside the proper bounds of this board, but you'd make a wonderful chair, sir. And you'd get all the support you could imagine from your loyal followers.
Yeah, I'll have to think about that. I was under the impression that we had settled on a chair at Mike's retirement. I thought Lynn was going to stay on.
Who was that person?
I thought when we had our discussion the last time when Michael, we talked about, we had this discussion and we sort of, I thought, and I guess incorrectly, that we were grooming Lynn to be the chairman, succeed Michael. And then I was going to stay on as a vice chairman. I feel my command of the statute is not what it should be, frankly. I do take comfort that I think Matt's command is extraordinary. And his continued presence does provide comfort. So let me think about it. I'd have to do some, I'd have to do a lot more work than I've been doing, frankly. I've been sort of coasting. Michael Monarch has made it very easy for us to coast, I think. And having Matt and Matt's experience, having a practicing lawyer with Mr. Todd, it's been easy to coast as the third or fourth person on this committee. And I indict myself for not understanding at this point the statute more fully, being more comfortable with it. Let me think about it.
Well, I too would be grateful and fully supportive if you'd consider that. I think there's also the matter that, I don't know if it's material or not, but Lynn, myself, and George are all listed as associate members. So I don't know how our reappointment plays into these positions, and whether we need to make sure selectmen appoint anyone taking chairs as full members.
Mhm.
That's a good point. Yeah. All right, well, I guess, Michael, let me think about it. I would certainly need a lot of tutelage, Michael. Well, let me think about it.
All right.
Maybe they're going to appoint a new person who'll be a superstar coming out of retirement.
Not unless it was that lawyer for the opponents of the Barley Neck. She was very impressive.
Yeah, there's been the level of representation in this is pretty good, frankly. So Sarah Tirana Perez is very good. They're all very good. Zender, we've had very, very good counsel before us, frankly, I think. I think it has to be continued because we have to get who's going to be, what the board composition is. We don't even know what it is yet. I'll take it under.
True, and I think we need to make sure to have it on the agenda for the next meeting. I don't even see this on the agenda for tonight.
Very well.
Michael, are you going to get back to the select board member that wrote you the email about, or probably is it something, what she said is, let me know what support you need to the committee, right?
I'm trying to remember. The only select board member that I've had communication with was Andrea Reed. I don't remember.
Right, and she just said,
I don't remember.
right, she said, your membership expires and let me know what support the group needs.
Okay, then what I need is a staff person to be trained to draft the opinions for the adoption by the board. That's what I would need.
That would really, I think that would help. I mean, I'm glad.
Right.
Do you want to take it? You and I can maybe send a note to her.
Yeah.
I'm glad to do that, but I'd like to confer with you.
Well, I will do it also.
Okay, and I think it would be good if we did have a session either separately from the next meeting or decide that we're going to have it at a separate time. And I think it would be helpful, as Bruce suggested, for it to be an executive session, because procedurally, there's a couple of things that I did want to talk to the group about. Sometimes I do think we need a lawyer's help before the meeting, get some advice, which we have not sought the town lawyer's advice. There's some things procedurally I think we should talk about. So could I think we need to set something up to have that discussion, and it probably shouldn't necessarily be public.
No, it's hardly but that's not a regular meeting, and it's not in connection with any kind of deliberation or business.
No, it's just how we operate.
And that
so-
you can do.
So let me suggest this, that I will reach out to the members as well as to Andrea Reed about what I want to know. When are they going to appoint new members, and when are they going to tell us that, right?
Yeah.
And we would like a staff person to help with decisions.
Yes.
And I will reach out to the group and suggest a couple of times that we could have our just an executive session on the process, and we need to figure out the chairmanship and give Jerry a chance to think about it.
Yeah, we could talk about it and talk about, that would be called an informal meeting, I think, and I would, I'll be there with you.
Okay.
If I may extend this one to a different issue a little bit, but to respond to one issue of Mr. Taub's concerns. And that is, I think that if we were not serving the town well, we would have heard about it by now. I think you have to take your judgment negatively. In other words, I've lived in this town enough to know that there were times when the health board was under concern. People were concerned with how things were going there. And I think that if we were off target in how the town thinks of itself, I think we would know. I think we'd be getting some pushback from the selectmen. They'd be getting concerns. And I think you have to take your acceptance negatively as opposed to positively. It's just one observation.
I would like to have an opportunity to discuss it, and this kind of it isn't, will not serve us or me. I mean, I'm just the guy who likes, Mr. Marnick said, transparent, democratic. I would like to know better what informs the views. To what extent I can't express myself adequately at this moment, and I don't want anybody to feel defensive. I am not being critical of the board's performance. I am suggesting that we're not necessarily aware of our own internal biases, for lack of a better word, and I'd like to examine it. And if it's not there, it's not there, and if it is there, it is there. Whether they're class biases or environmental biases or whatever they might be that inform our decisions, and that, again, to my mind, have to do with who takes responsibility for what. And we get pushed to the edge on the cases that challenge that, the Atlantic Workshop being one and Barley Neck being another. It wasn't so much so with the Nauset Marine people, but we're being called upon to arbitrate at times certain values or visions. That's all I want to say. And it might be nice to talk about that once, since we are supposedly representative of. I'm not saying we're not doing it well. I'm just saying I'd like to look at it.
I have a similar, I'll just say, Bruce, because I know we want to close down for the night, it's late. I have a similar, not quite the same, but desire, and Michael knows, to talk about the issue of precedent. It bothers me, and has ever since I joined the board. So there are some substantive matters that I think having a discussion would be helpful for me to clarify what I do think. So I think there are some issues like Bruce is raising that would be useful to take offline as a group. So I agree.
I think that's right. I think we will need George Moore in those. discussions.
Yes. Can I
George,
suggest?
yep,
He has a lot of
Didn't-
experience and he has strong views on those issues.
I know he does,
Yeah.
yep.
You know, on the website, it still says that we don't meet in August, though we agreed that we would continue to meet in August. It might be that one of our regular August meeting dates we could just preserve for this purpose.
No, we never actually agreed to. We raised the issue, it was never resolved about meeting in August.
All right, well, then, under
Another one.
those circumstances, perhaps there's an August opening.
Sure.
All right, well, I will, to deal with some of the procedural and substantive issues, I will work with Michael to suggest something to the group. And I will chair the next meeting, so we can at least know that we've got that covered. And I will reach out to Andrea Reed about when are we going to get appointments and the issue of getting some more. I think we all would agree it'd be good to have some staff support on the decisions.
Absolutely. Thank you, Lynn, for doing that. I appreciate
Okay,
it.
I'll
Could
do
I
that.
just say
Okay.
that it may be that Andrea Reed is waiting for us rather than vice versa, that we ought to tell her that the following people wish to be reappointed, that it's an affirmative
Right.
step we
And-
take rather than waiting for them.
I think we know everyone, and I've pretty well talked myself in this evening to being reappointed. But I think we know everybody except for George. I haven't seen anything about George. Does
I
anybody
can't
know?
imagine that he doesn't want to be in. He just
So-
started again.
I'm not, is his term up? I'm not sure. his
I don't
term
think it is, I don't think it
Oh,
is.
no?
No, so he wouldn't have.
Oh,
to-
okay.
He's
Ah.
in.
So he's there. He's in. Okay. All right.
Move to adjourn.
Very well.
Hey,
Thank
Second.
you all.
Thank you
take
all.
care.